Mr. Barbano, this is probably one occasion that doesn't come across very often where you don't need an introduction. Weren't you with us a couple months ago?
That is correct, Your Honor.
Well, welcome back, and we know you're here under the student practice rules, so you may proceed.
Thank you, Mr. Chief Justice. Ms. Chambers, may it please the court. My name is Samuel Bourbano, and I represent the appellant in this case, Ms. Karen Huston. At Ms. Huston's trial for child endangerment causing serious injury, the state offered a DHS administrative conclusion of child abuse and information about the procedures to appeal it. That information was both not probative and unfairly prejudicial. It was admitted over the defendant's objection, and because of that, and the lack of evidence of serious injury, Ms. Huston's conviction should be reversed. I'd like to start with an Iowa case that cuts to the heart of the relevance question. In Iowa, this court held in a state of Johnson that a criminal conviction proves only the conviction and not the facts that back it up. So even when the defendant is possessed of the highest adversarial safeguards which Ms. Huston did not have in the DHS investigation, the conclusion only proves the conclusion and not the facts back of it. That idea of relevance is echoed by another case. The parties do not appear to have found another appellate decision outside the one of the lower court in this case that would approve of the admission of an administrative report of child abuse above a general relevance objection. But there is authority from the Supreme Judicial Court of Massachusetts in Stuckich, submitted last week, and I would read the excerpt in full. The description of the investigative process suffers from the same infirmity. The fact that the Commonwealth brought its resources to bear on this incident creates the imprimatur of official belief in the complainant. It is unnecessary and irrelevant to the issue of defendant's guilt and is extremely prejudicial. To cite but one example, the fact that Horan, who is the mandatory reporter, was mandated to and did file a Section 51A report establishes nothing other than the impermissible inference that Horan believed the complainant. It has no relevance to whether the defendant in fact committed the acts charged, and the jury did not need to know how the complaint of abuse evolved into the case before them. I think that is applicable in many ways. So I'd first like to start with what was the purpose of offering this report?
Mr. Bourbano, I have a lot of problems personally with the DHS conclusion getting into evidence, but I'm very interested in the issue of whether it was harmless error. It does seem there was a lot of evidence that this child was malnourished, and it seemed to be pretty undisputed that the child was living with your client and her husband during the time period where the child was malnourished. So, help me out. Where was the evidence and conflict, and how did this tip the balance?
I'd like to start first with the grounds upon which the report was founded. The DHS worker testified that this report was founded on physical abuse, neglect, denial of critical care, and deprivation of food. Now, for the state to put those three grounds on the scales, in addition to the issue about deprivation of food, is to put those issues before the jury and say, look at what a bad person she is. If it's not enough on deprivation of food, then surely these other three grounds are enough to make up the slack and tip the scales. The second issue about harmless error is the question of whether Ms. Huston had care and control of the victim in this case, Ms. Huston being 375 pounds, having not walked up the stairs of her house and sleeping in a bed in the kitchen, certainly might vitiate the argument that she had care and control. And so the burden being on the state to prove that this wasn't harmless error beyond a reasonable doubt, I don't think is met. But more importantly, the introduction of that report's conclusion made this trial not about the facts at all. I mean, here are the facts, the underlying facts. Here is the investigator's conclusion, and then here's evidence of the appeals process. We get further and further away from the underlying facts of the trial itself. And so the result of the trial cannot be harmless error, Your Honor.
Counsel, there was later testimony about the process and the investigation that came in without objection. Did that in any way waive the right to appeal the alleged error for telling the jury the investigation had been founded?
No, Your Honor, because the testimony of the other DHS agent was not the same type of testimony as was objected to over here. Page 7 of the transcript includes question, when was the most recent time that you've investigated allegations? Answer, I have received a report on October 19th of 2010. And she says the report found a resolution, but that is not the same type of testimony objected to because it ignores, it doesn't talk about those 4 grounds that are irrelevant and prejudicial, and it also doesn't get to the conclusion of it being founded. There were other arguments raised by the state as to why this is admissible, the idea that this is an expert opinion. And there are 2 issues with this being an expert opinion. The first is that this is a DHS report, and the agency is not an expert witness. But more importantly, an expert opinion has to be important to helpful to help the fact finder understand the scientific or technical issue beyond the ken of a layperson. And here, the conclusion was offered to prove the bare existence of the facts behind it. And it wasn't, the state didn't lay the predicate and ask for what are the health consequences, what are the developmental consequences, what are the psychological consequences, as they did with a doctor, and that would make his or their, the 2 doctors, their conclusions expert testimony. There's another...
Did the trial court give a curative instruction of any kind to undo the damage?
No, Your Honor. I don't believe one was requested. There were a series of objections in the transcript leading up to the evidence of the conclusion, evidence of the appeals process, and then right before the witness answered the question, did Ms. Huston appeal, that objection was sustained. And there was no curative instruction requested to disregard the question. Although I think the lack of a limiting instruction is certainly very relevant in this case, because for those 4 grounds upon which the report was supposedly founded, to prevent an emotional reaction of the jury, to prevent that unfair prejudice from arising when this child abuser, this person denying physical care or critical care, and this person neglecting her child are all offered, to prevent that from being considered on an emotional basis or a potentially unfairly prejudicial basis, an instruction by the court is certainly in order. Continuing on to evidence of the appeals process, I think that the further away we get from the underlying facts of the case, the less likely it is that that information is probative. I would draw an analogy to the way that extrinsic impeachment evidence on a collateral issue is not admissible, because the further and further we get from the central issues of the case makes it less and less likely to be relevant. I'd also like to turn to the evidence of serious injury. And returning to your discussion of the facts, Your Honor, the facts certainly show injury, but as far as the meaning of the statute, serious injury does require more, and that was not met in this case.
Well, why not? The child had lost considerable weight, which at the weight level we're talking about was very substantial. He had pallor. She had pallor that was unusual. She was losing hair. Doesn't the record support the notion that the child certainly was at risk of death absent intervention?
Your Honor, the way I would respond to that is with the testimony of the physicians themselves, that the statute doesn't require a mere risk of death, mere possibility of death, mere mere likelihood. But the statute demands more, specifically a substantial risk of death. And a present substantial risk of death wasn't elicited by the physicians when they testified.
Let me see if I understand. So your argument, tell me if my summary is inaccurate, is the state proved not that the person was seriously injured on November 1 or November 2, 2010, when she was taken away. What they proved was if she had stayed where she was going to be seriously injured, and that's not enough. Is that basically your position in a nutshell?
That is correct, Your Honor. And I believe that that is supported by the testimony, which sets up serious injury, but then adds a condition, if, and then also a subjunctive could. With the questions, do you believe those injuries or conditions would have created a substantial risk of death had the victim not been treated? That is not only not a serious injury right now, but it also is an unknown time as to when that might ripen into serious injury.
Well, unfortunately, the code says exactly that, though. It says serious injury means a bodily injury which creates a substantial risk of death. That's right out of the code. And isn't that what the doctors testified to?
I don't believe that is what the doctors testified to, Your Honor, because when the doctors responded to those questions, they are conditioning their response at some future point, as she goes untreated, then this will become serious injury. I mean, another way that I would read those responses is she is not serious at this time, or at the time that she was examined, she did not suffer a serious injury.
What you're saying, and I'm going to recharacterize it too, that at the time of hospitalization, that no one testified that there was a present risk of death, that they weren't sure whether they could save the child.
That is correct.
Instead, they were intervening to prevent a process that was underway that might lead to death.
That is correct.
If not, if there was no intervention. And so then the question becomes under our statute whether those facts are sufficient, I take it.
And I don't believe that they are, Your Honor, because of the subsequent case law. We cited to state against Michael Maddox, where Mr. Maddox was hit by, put into a river, floated downstream, and then got out cold and shivering, and for 45 minutes had to find his way to a convenience store. This opinion is unpublished, but its reasoning is applicable here because the river, in this case, is that process to which you referred to. And the reasoning is that had more things happened, then that would have created the substantial risk of death. But on its own, the mere placement into the river or the dangerous situation was not enough to constitute serious injury under the statute. Seeing no questions from the panel, the right to a fair trial protects all defendants, especially those who, by reason of the charge or their condition, are least deserving of the jury's sympathies. The state took that right away from Ms. Huston when it offered evidence of the founded DHS child abuse report.
I guess I have one question before you sit down, if I could.
Yes, Your Honor.
So the objection is simply to the report itself and the conclusion that it reaches in the DHS report itself. Do you have any objection to the testimony of the DHS worker who describes in detail all the, without getting, if she didn't get to the ultimate result, we didn't have the DHS founded report in the record here, and she never made that statement or conclusion, you're saying it would have been all right for her to testify to all these various facts leading up to that conclusion, wouldn't you?
I would say that certain of her observations, had I been trial counsel, maybe there's a hearsay objection that might have been sustained or that might have been made, but certain of her objections, certainly the things which she observed as a fact witness, would be admissible. So that which she saw or upon investigation of the home, or maybe the things that the victim said, might be admissible. But the conclusion is the thing that is the most dangerous, Your Honor, because Going back to Stuckich, it carries the state's imprimatur. It has that seal of approval that is so prejudicial and was so prejudicial in this case.
I guess, does that enter into our harmless error analysis to say everything that she said up until that point would have been fine, or could have been fine, could have been objectionable, but overall it probably would have gotten into the record anyway, but because of this factor of getting in the actual report itself, that takes it out of the harmless error type of analysis?
No, Your Honor, because the other aspects of the harmless error analysis require the state to establish beyond a reasonable doubt that the defendant hasn't suffered a miscarriage of justice. And to go back to the 4 grounds upon which that report was admitted on, each of those upon the scales, tipping the balance of unfair prejudice against the defendant and denying her her right to a fair trial. Thank you.
Thank you as well, Mr. Barbero. Ms. Chambers.
May it please the court, counsel. This case presents a perfectly ordinary trial with perfectly reasonable evidentiary rulings by the district court and reasonable representation by counsel. The Court of Appeals looked at the claims raised by Ms. Huston, rejected them handily, and on further review, the defendant has shown no reason why this court should reach a different conclusion.
Counsel, is there any case that that holds it's permissible to tell a jury in a child endangerment charge that the investigating state agency determined it to be founded?
I didn't find any Iowa case, and I frankly, in a quick search, didn't find any out of state. But I analogize it, Your Honor, to what routinely happens in criminal cases, and that is that the investigating officer comes in and says, I investigated, I arrested, here we are. And that's really all that this social worker's testimony amounts to. I investigated, I found that there was enough to turn this over, that's what I did.
I think maybe a better analogy, I had an insider trading case once, and the SEC found that a civil violation by my client, and I can say we fought very hard to keep that out of the client's criminal trial, and we're successful in doing so, and the U.S. government didn't really object to it. Isn't it that more of an analogy? Because you have really a finding of guilt under a lesser standard and with fewer procedural protections that you're introducing. Isn't that a better analogy?
I think not, Your Honor, and here's why. The jury is familiar probably with kind of how routine criminal prosecutions or investigations go. But I think what was really happening here is I actually see it from the opposite point of view. I think what was going on here is that they were explaining to the jury that these kinds of investigations aren't criminal, that they don't have to end in prosecution. That's not the goal. That what this social worker does is goes in and sees whether there's reason to take steps to protect the child's safety. And that's really a very different question as to whether there's enough evidence to prosecute, and certainly whether there's enough evidence to convict. So
it makes sense to me that she's allowed to testify about what she saw, maybe what the defendant told her, but why go over the line to say it was determined to be founded, this administrative finding by a preponderance of the evidence? That seems to me that would risk skewing the outcome, that jurors would give that more weight than they should, when I don't see that it should get any weight.
Well, the state certainly doesn't concede that testifying that it was founded crosses the line. But yes, would I prefer she hadn't used that term? Yes, I would. And as lawyers, I think, and judges, we kind of pounce on that because to us that means something. To a juror, that just means, well, that's some word. And then she defined that as that means that we have more, the balance tips in favor of intervening to take steps to protect this child. So I think to a juror, that word founded doesn't have the same, it doesn't raise the same red flags that it might for us. But yes, I would prefer she didn't use the word. No, I do not believe that crossed the line, and I certainly don't think it was prejudicial to the trial in this case.
Talk about prejudicial. I kind of looking at the testimony, it seems like the witnesses all testified that the other person was responsible for feeding this girl held. Mandy said the parents did, and the defendant said that her husband did, and her husband said, no, I didn't, you know, and that really would have been the issue. I mean, who is knowingly, intentionally depriving this child of food? And that seems like a hotly contested issue, especially given the defendant's physical disability. So help me a little with that.
That was an issue at trial, but I think one of the things the social worker was trying to point out in her testimony is that isn't the issue when they're investigating child abuse. At some point, they're going to sort out who that is. But the first thing they do is find out whether there is abuse, period, no matter who did it. So at the stage at which Ms. Boyer, who I unfortunately occasionally renamed Ms. Boyd, and Ms. Andreski were investigating the allegations of child abuse, it was a side issue as to who was committing the abuse. The real issue was, is this the result of child abuse? And if so, what do we need to do to address it?
Doesn't that make the finding even less relevant then?
I think it makes it not less relevant. I think it makes it less probative. It still explains why she was doing what she did, why she talked to the people she talked to, why she had the child see the doctor, why she requested an out-of-home hospitalization.
Why does that need to be explained? Just say she did it. I mean, I understand sometimes the state has this idea that otherwise, evidence that might otherwise be inadmissible needs to come in because it's sort of part of the narrative or part of the story. And I have to say, I'm sometimes baffled by that kind of explanation of relevance. I mean, why was that? Why did that have to come in? Why was it needed?
Could the case have been prosecuted without it? It could. But jurors want to know how we got here, and they deserve to know the story. So they deserve to know, and the state deserves to prove, they didn't just sweep this girl off the street and plop her in the hospital and press charges against her grandparents, her step-grandparents. That there was a process that was followed, and here's what we did, and here's how we got here. So that, you know, if you ask me, if someone asked me what I did today, and I didn't tell them, and I said, and then I changed out of my suit into some comfortable clothes, that would be baffling to them unless I told them what came first. So, you know, I got dressed up, I went to court. You know, we start in human life, we start at the beginning and we tell the story. And when we don't do that, jurors suspect we're hiding something. So nothing prejudicial came out in these social workers' testimony. They simply said, we investigated, then we saw, and then we turned the case over to the lawyers. And from there they took it. And everything, I mean, there's overwhelming evidence in this case on the elements of the crime. So this can't be harmful. Yes, I would prefer she didn't use the word founded. Had she asked me, I would have told her not to, and I would note that the second social worker who testified didn't use that word. I suspect that's not an accident.
Counsel, on whether this error is harmless or not, how many other adults were involved in the care and feeding of this child during that time?
Well, there were a number, according to the statements that were made in the course of the investigation, and again, this I think is why it's important to say what they did. In the investigatory stage, Karen Huston and her husband initially denied being in having care in custody, and the stepmother, Mandy, said she sometimes was in charge of feeding and sometimes not, and the natural father was apparently kind of not involved at all. But by the time of trial, and I think this is important, by the time of trial, Karen Huston testified that she was the person who had care in custody and she was the person in charge of feeding TH. So at trial, the defendant resolved that issue.
What do we do with the testimony about that the child may have had some eating disorder or problem with keeping food down?
The expert witnesses did not testify to that. The defendant and some of the family members testified that TC would eat until she vomited, and it was the defendant, Karen Huston, who suggested she had an eating disorder. I would point out, first of all, that eating to the point of vomiting is completely consistent with being deprived of food. When she got food, she ate so much that she vomited. And once she was in a foster family, the foster mother testified that when she was first there, TC would eat until she vomited, but that resolved itself likely because she had ready and routine access to food. But there's no expert testimony that there was an eating disorder here.
I'm kind of looking at this a little bit in conjunction with one another, not only the putting in the founded, that it was a founded case of abuse and neglect, but then when they follow the next question up with the process for appealing, and then she doesn't appeal, is my understanding. So it almost, to me, is like, well, they made this determination, and then she didn't dispute it, so that's basically an admission. You see what I'm saying? It seems to compound itself, not just the fact that the statement was in, or the report was in, but then it seems to be compounded, because then when you go through the whole appeal process and she doesn't do anything, you see what I mean? It almost appears like it's an admission, again, that's being used against her as part of this process as well, maybe unfairly.
I do, but I hasten to add that there is nothing in the record that this defendant failed to appeal the administrative finding. I think that's the conclusion the defendant would like the court to draw, but that is not in the record. The question is there a process to appeal? Yes. And did she appeal? Objection.
And I do see that, so I thank you for
and
that.
that's exactly the conclusion I think the defendant would like the court to draw. But so,
why was it relevant that there was an appeal process?
I think, Your Honor, you'll notice in the state's brief that we did not defend that on the merits. We just simply jumped to harmless error. I will say that I can think of a reason why that would be admissible, and that is if what was going to come next, and we don't know what comes next because those questions were not pursued then, but if the answer was going to be if there is a process to appeal, the defendant did or did not appeal, and here's what would have happened in that appeal, because the answer to that under the code is the defendant would or would not have been placed on the child abuse registry. It really would have nothing to do with a criminal prosecution. And it may have been, and this is kind of speculative, but it may have been that they were going to go through the lines of explaining the whole process and how that differed from the criminal process, but we'll never know.
Let's go into the injury issue, and I want to break it down into its components as I understand it. But first, in your view, does a record support that at the time of medical intervention that there was a present risk of death, first, as a matter of fact?
I think it does. The Dr. Artinian testified, and I want to see if I can get, I believe that something catastrophic was going on. I think he says, in fear for her life. And if you look at the kinds of things that they did, I think that backs up the doctor's testimony that he was fearful that she would die. He tested for, and I quote, pediatric emergency situations. They tested for diabetes, HIV, cancer, malabsorption issues, serious things, which would back up his testimony that he was seriously concerned that this child could die. And the test of serious injury isn't will die, would die, is just substantial chance of that. It doesn't even have to be, I think in the Anderson case, a doctor testified there was a 10% chance the elderly victim could have died. So it's not a horribly high standard. And I think the doctor's testimony here and their actions show that they met that standard.
Would you clarify, you indicated that Dr. Artinian recounted the tests for emergency conditions. Mm-hmm. Did any of those tests produce positive results?
No, they did extensive testing to try to rule out anything they could think of, and nothing was found medically.
And then how does that then address whether there was serious injury or not?
Well, I think the most important part is, one of the more important factors is that it establishes that it was the lack of food that caused these physical things and not some medical condition that would not have been within the control of the defendants. But then the second thing it does is, because the doctor testified, I was afraid for her life. And then he backs up he demonstrates the degree of his concern by the kinds of tests he runs. He didn't.
Yeah, but being afraid, he was afraid for her life, maybe because he was fearful of some process other than malnutrition. Maybe he was concerned about cancer. Maybe he ran all these tests. Isn't the question a narrower one, which is, at the time of intervention. Is there evidence in the record that the physicians were concerned that malnutrition that she was at a present risk of death because of malnutrition?
Yes, I think you have to kind of piece it together, but they're saying, given her emaciated state, we were concerned for her life, that she could die. And given that we now know that, and given that they took actions to determine what the cause of that was, and you put those together, and they were concerned for her life because she wasn't being fed enough. The fear itself is the same, but you have to tie it together with the cause, and that's what those tests do.
Let me follow up with a legal question then, and that is, does the law require that there be a present risk of death, or if there was a process in place, would that be sufficient?
A process is enough.
And why do you say that?
For example, there are cases where a person who is not currently bleeding out on the table, the court found serious injury based on the fact that if the bleeding were not stopped, that could cause death. Similarly, the court has referred to infection, and not currently in danger of death by sepsis, but if the infection were not checked, could cause death. So a process is contemplated by the statute. Typically the processes are a little more compact than starvation presents, and I think that's what makes it a little harder to think about. But the process is, this child is not being fed, she's not growing.
Serious injury means a bodily injury which creates a substantial risk of death. All right. Now, November 1 or whatever, she's removed. So don't we look at the bodily injury to that date, and is there a substantial risk of death at that point?
I'm not sure I agree with that, and the reason I say that is because of the bleeding cases. I think it might be Coburn. I think it is Coburn, where there was a young child sex abuse victim who was hemorrhaging as a result of penetration. And the record in that case was not that she was going to die as of that date. The testimony and the court's finding in that case was, if she continued to hemorrhage over the course of time, she could die either as a result of the loss of blood or infection setting in. So the statute and the court's decisions under the statute do contemplate a process and do allow us to kind of look forward into that process to see what would have happened had medical professionals not intervened. Again, typically it's a little quicker. If people are going to die from blood loss, they aren't going to do it over a course of days, weeks, and months. They're going to probably do it a little quicker than that. So to that extent, starvation is a little bit different, but the legislature specifically included deprivation of food when it rewrote the child endangerment statute in 1985. So it absolutely intended to include deprivation of food as one of the things that could qualify under the statute. I mean, specifically provided for it. And they could not have been unaware that starvation, unlike other kinds of injuries, is a process. So I do think it's absolutely covered by the statute. I'm out of time. Thank you.
Thank you as well, Ms. Chambers. Mr. Burbano.
Thank you. I'd like to begin with Exhibit 14, where Dr. Frank Artinian is offering his opinion to DHS. And in that opinion to DHS on November 1st, he states phrases like well-being. I am very concerned about her well-being, not I am very concerned that she is in serious injury or that there is a danger of imminent death. He also says, I cannot state the following in strong enough language. As a pediatrician, I have grave concerns regarding the physical and mental health of the victim. I am very concerned that she is undergoing abuse and neglect in her home, which goes to the point that this may have been an injury, there may have been that deprivation of food, but it would not rise to the quantum of serious injury. Going to the old chief, the storytelling aspect of the finding of child abuse, old chief recognizes that narrative richness still has to give way to unfair prejudice. That is, where there is the substantial danger of unfair prejudice, the correct decision of the court is to not admit that evidence or to redact or limit it so that that way they have an alternative which is equally as probative but without that danger of unfair prejudice. That goes back to the question, couldn't you just say, I did this and then I did that? I mean, if the prejudicial material is, I went to court, then just say, I went to work and then I'm changing into my pajamas. Here, the testimony that the report is founded is that prejudice, precisely because of the grounds upon which it is founded, those additional three.
Did the defendant admit that she had custody and control of the child, and if so, what do you make of that?
I believe the defendant answered that she did have custody and control of the child, and I'm not sure what to make of that because of the question earlier about everybody sort of saying it was the other person. I would view that comment holistically in view of everything else that happened at the trial and all of the other evidence about the defendant's condition and who did what and when, to say that that is not conclusive evidence that she had care and control of the victim in this case.
You still, the prosecution still had to show basically intentional deprivation of food by your client, right? Isn't that what in essence, what the charge was?
Yes, Your Honor.
So, I mean, whether she had care or custody, if she truly believed that other people were feeding her, that would still be a defense, right?
I think so, Your Honor. And so that's what makes the admission of the report's conclusion so prejudicial, because if there's not enough on deprivation of food, then, I mean, look at all these other bad things the defendant has done. And that being enough to make up the slack is the danger. And the other danger that I didn't address very well in the opening is that the lack of adversarial protections that are due to the defendant. A hypothetical might be, with the rule, an adverse rule in this case, might be that the conclusion of an administrative report, an inquisitive process, where an inquisitor can call whatever witnesses she wants, without the protection of counsel, without the jury, without the heightened evidentiary standard, and then offer that conclusion with a wink and a nudge to the jury down the road to say, well, you know, forget all this talk about the defendant's rights. We have kind of taken not the straight and narrow way, but, you know, the back way, the shortcut that gets right to that conclusion. And here's the conclusion. The defendant is a child abuser. And with that on the books, it is very hard to see how the defendant didn't suffer a violation of her rights and how this is harmless error. We respectfully request that this court reverse the judgment of the Court of Appeals and remand to the district court with instructions to either dismiss or, in the alternative, enter judgment on the lesser included offense. Thank you.
Thank you as well. Mr. Burbano, I want you to know you've argued now twice before this court, and you've done an outstanding job on both occasions.
Thank you, sir. Wish me luck on my trials.
Yeah. Well, yeah, you're supposed to be in finals right now, aren't you? Yes. Well, I want you to know that your performance here the last two times doesn't mean you don't have to take the bar when it comes time. All right.
Even the chief's son has to take the
bar. Yeah. Okay, that'll wrap things up, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.